Hi, it's Massachusetts OUI Lawyer Michael DelSignore. In today's video, I want to talk about what happens if someone is seriously injured and you're charged with OUI. So this is not just your regular OUI, there's a serious injury. So you're charged with OUI Serious Bodily Injury, and there's two versions of that. One's a felony, one's a misdemeanor. If it's OUI Serious Injury with negligent operation, that's a mandatory jail sentence of 6 months if it stays as that charge. That's a felony offense. The other version is OUI Serious Injury without negligent operation. That's a misdemeanor. You could get probation for that. Often, if you're charged with the felony version, a strategy would be to try to do alcohol treatment, counseling, to show that this isn't going to happen again, to get an offer of a reduction to the misdemeanor version. Now, you're not obligated to take any plea if they reduce it, but sometimes people want the option. They want to know, is there a way to resolve this case short of trial without facing jail time? So those are the two versions. OUI Serious Injury, you got the felony, misdemeanor version. So when there's a serious injury, this is certainly a case where jail time is on the table. Typically with a first offense, you're not looking at jail time. But if serious injury, even with it being a misdemeanor level, you can't discount the fact that a judge may be compelled to put somebody in jail because someone was seriously injured after a drunk driving incident. Now, why is that? Our judges are great in Massachusetts. We have very compassionate judges. They don't put people in jail just for the sake of doing it, but generally they feel as though they're compelled, they have a reason. And some judges may feel, and sometimes if you go to trial on a serious injury case and there's a guilty finding, the victim's going to make a statement. Sometimes these victims can make very passionate statements, and it puts the judge in a position where they feel like they're ignoring somebody who's injured if they don't give a harsh sentence, where maybe if there wasn't a victim or if it wasn't after trials in an earlier stage, the judge would give a lighter sentence. So what you want to do is you want to give the judge as much ability to be sympathetic to you as possible. So start with AA, counseling, treatment. And that doesn't mean you're guilty. In other words, a lot of people think, geez, if I start doing that, aren't they going to think I'm guilty? Not at all. If you win the case, no one will ever know about your treatment. And if you lost the case, you're going to be thankful you did it. Sometimes it can be a suspension for immediate threat. In that case, the registry is not going to even care about the not guilty. They'll want to know that you've done alcohol treatment regardless of the verdict. So somebody could be found not guilty, and the registry will say, well, geez, this report lets us believe, and we don't have to require proof beyond a reasonable doubt, but just on a public safety standard that you might have a problem. So show us that you don't get the alcohol treatment. So it's a great thing to do. Never a downside in any kind of case, but certainly if someone's seriously injured, you want to be able to show as many efforts that you made to change who you are in the event there is a conviction. Now, they still have to prove the OUI, so that doesn't go without saying that that's a done deal. Just because someone's seriously hurt, maybe they were at fault for the accident. Maybe you were not impaired. It could have been you just weren't paying attention. There was an accident. It's unfortunate. It doesn't mean someone's under the influence. So if there's an accident, certain field sobriety tests, booking videos, all those things that go into any type of OUI will try to minimize the officer's observations, show that the field tests don't show impairment, that you could have been nervous, injured from the accident, that maybe you did well and the officer didn't give you credit for it, that you were mentally sharp and alert, responded promptly, appropriately, were polite, cooperative, and that the signs that they saw were not reflective of how somebody would act if they're impaired. There may be a charge of negligent operation in addition to the serious injury. Potentially, maybe that could be resolved, or there would be a conviction on that, but not on the OUI with the serious injury. So if there's a breath test, there's ways to get that excluded from evidence. We can challenge the admissibility of the test, so you don't have to resolve a case just because there's a breath test. We can fight a case with a breath test as just an extra step. Sometimes there's statements that we might not have to knock out or admissions. So if you're charged with OUI Serious Bodily Injury, keep in mind the two misdemeanor and the misdemeanor felony aspect of this. Contact me as soon as possible so I can help you get on the right track. Start doing those things to give you more options and preparing your defense. Call, text anytime. My name is Mike DelSignore, 781-686-5924.